This is a University of Otago podcast.
Distinguished guests, colleagues, students, and everyone who's come along, thank you for coming along to this very special occasion in the Law Faculty's life every year. This is the 44th FW Guest Lecture, and as many of you will know, this lecture was made in honour of Professor Frank Guest, and I'm sure there are members of, I can't see if Jim's here, I'm sure he's here somewhere. There he goes over there. Yes, members of the Guest family here, so thank you for coming along. Professor Frank Guest died far too young, and he taught people like John Smiley, so he had a hard life. No, I'm just joking. And he was a fantastic academic. He was the first full-time dean and professor of this law faculty, and in his honour, since 1968, we've had this annual lecture, and many distinguished people are giving it. And I'm sure Professor Guest will be delighted with this year's particular FW Guest lecturer, Professor Andrew Ashworth. Andrew is here as the New Zealand Law Foundation Distinguished Visiting Fellow for 2012. Andrew is the Vinerian Professor of English Law at the University of Oxford, which is the oldest professorship in the common law world. Professor Ashworth is also a Fellow of All Souls College at Oxford, and he is a member of the Centre for Criminology at Oxford. He's a Fellow of the British Academy and was made an Honorary QC. He was awarded a CBE in the Queen's Birthday Honours in 2009. In his academic work, Professor Ashworth has written a number of books, and I'll just mention a few here. The Principles of Criminal Law, which is in its 6th edition. The Criminal Process, which was jointly authored in its 4th edition. Sentencing in Criminal Justice in its 5th edition. And Human Rights in Criminal Justice, which is 3rd edition, just about to come out with some practitioners, also jointly authored. Currently, Professor Ashworth is the co-holder of a large grant from the Arts and Humanities Research Council for a 3-year study of the justifications for using coercion for preventative purposes. Professor Ashworth's main teaching area is human rights law. But apart from the academic world, and I think this is important, Professor Ashworth also has been very active in the public arena. He's been a member of the Criminal Law Revision Committee, chairman of the Select Committee of Experts on Sentencing at the Council of Europe, and chairman of the Sentencing Advisory Panel in the UK. So it's with great pleasure that I invite Professor Andrew Ashworth to give the FW Guest Memorial Lecture on negotiating the fundamental right to personal liberty for problem cases. Please give Professor Ashworth a big Otago welcome.
Well, good evening, everyone, and thanks for coming. I'm really delighted and honoured to have been invited to give this lecture. I've been to this law school before, and the welcome is always very warm, and I'm delighted to be here tonight. Thank you very much, Mark. Tonight I've chosen to talk about the right to personal liberty. Now, I'm not going to talk about liberty generally. I'm going to talk about liberty in the negative sense in which it finds expression in many human rights documents. It finds expression, for example, in the New Zealand Bill of Rights Act. Section 22, you'll be familiar with, liberty of the person. Everyone has the right not to be arbitrarily arrested or detained. An interesting provision because, of course, in the text it doesn't mention liberty at all. So it's negative. It's saying what should not be done to people. Concepts like arrest and detention are the key, but the word arbitrarily attracts really all the attention there. And you can see that by contrasting it with the European Convention on Human Rights, which is much more wordy. Now, I don't want you to focus on this, which is why I put it in such small type. The important point, well, no, seriously, the important point is the enacting part. Everyone has the right to liberty and security of the person. No one should be deprived of it, saved in the following cases and in accordance with the procedure prescribed by law. And then there are 6 exceptions which are described at great length. So all that is the European way of saying what the Bill of Rights Act says much more tersely. And interestingly enough, the European Court of Human Rights has said that what Article 5 really means is that liberty shouldn't be taken away arbitrarily. One word which doesn't actually appear in the very lengthy statement in the article. So why do I want to talk about liberty? Well, there is a compromise that is at the heart of modern society, and indeed most civilized societies, and that is that although we believe in liberty, we also accept that there are certain respects in which our liberty can properly be taken away, because we expect the state and its law enforcement officers to prevent crime, to preserve public safety, and to investigate offences. So those tasks, particularly the task of preventing crimes, are part of the democratic compromise, and we have to give the police the powers to do those things, otherwise it would be meaningless. So we give the police certain powers which cut into the liberty which we would otherwise have. And in doing so, we have to accept the possibility that however innocent we might be, our liberty actually may be taken away by a police officer acting on reasonable grounds. So in this paper that I want to look at 4 situations where these matters come into play. First of all, police stops, stop and search. Secondly, police restrictions on movement during demonstrations. Thirdly, PreTrial detention. And fourthly, indefinite detention of so-called dangerous offenders. So let's begin with police stops. The question is, when do police stops amount to a deprivation of liberty? I want to take you to events in London about 10 years ago, when there was an arms fair in East London, and many people were demonstrating against the selling of arms to certain countries. The police were around patrolling, and that day they stopped Mr. Gillen, who was riding his bicycle in the direction of the demonstration, intending to join it. And they also stopped Miss Quinton, who was a journalist who was there to take photos of the event. They stopped them both for 20 minutes, searched them, verified their identity, and then let them go along their way. Although during this procedure, they ordered Miss Quinton to stop filming. Subsequently, Gillen and Quinton brought actions for judicial review against the police, claiming that their rights had been violated. They got no joy from the English court, so they applied to the European Court of Human Rights in Strasbourg, claiming that their rights under Articles 5 and 8, which I'll come to in a moment, had been breached. Well, why did the English courts not think that this had happened? Well, in the House of Lords, the House held that there was no breach of Article 5, which is the liberty of the person one that I mentioned previously, because in Lord Bingham's words, the appellant was merely detained in the sense of being kept from proceeding or kept waiting, and therefore this was not, in his view, a deprivation of liberty. So it didn't bring all the provisions of Article 5 of the Convention into play. It was not a deprivation of liberty. Lord Bingham also went on to consider whether there was a breach of Article 8. Now, I haven't introduced Article 8 to you. Again, it's a rather lengthy article, but its essence is respect for private life, home, and correspondence. And the question that the court had to address here was whether there was a breach of Article 8 in the search that these two people were subjected to. Lord Bingham again held that there was no breach of Article 8 because an ordinary superficial search of the person and an opening of bags of the kind to which passengers uncomplainingly submit at airports, for example, can scarcely be said to reach the required level of seriousness. So the House of Lords dismissed the claims on this issue. There are lots of other issues in the case which I'm not going to go in. I'm focusing on this question of whether there was a deprivation of liberty or some other violation of human rights. The case went to Strasbourg, as I mentioned, and the Strasbourg court answered the questions the other way around. They started off with the right to respect for private life, Article 8. And they said, irrespective of whether in any particular case correspondence or diaries or other private documents are discovered and read, or other intimate items are revealed in the search, the court considers that the use of the coercive powers conferred by the legislation to require an individual to submit to a detailed search of his person, his clothing, and his personal belongings amounts to a clear interference with the right to respect for private life. Now, that's a very strong statement against what the House of Lords had suggested on Article 8. So let's just look a little bit further at that. Was Lord Bingham right in the House of Lords to suggest that what he referred to as a superficial search was really not serious enough? Well, if you look at the police code of practice, which governs these kinds of encounters, it says that a police officer may place his or her hand inside the searched person's pockets, feel around, and inside his or her collar, socks, shoes, and search the person's hair, as well as turning out the contents of any bag carried by that person. So this is quite intrusive stuff. And I think that it provides some justification for the European Court taking the view that they did, rather than Lord Bingham's rather different approach. What about Lord Bingham's analogy with airport searches? Does that get us any further? Was this like an airport search and therefore not something we should worry about? Well, I think there's a difficulty there, because for airport searches you can actually throw away anything that you discover. Oops, I've got a nail file that's sharp, or oops, I've got a pair of scissors. You can throw them away without any suggestion of culpability. Whereas, of course, if a police officer is about to search you and you throw an article away, then that wouldn't go down well at all. So the whole ambience of the two transactions is rather difficult. And to say that, on an aircraft, if you don't want to be searched, it's arguable you could decline to travel, although I don't imagine that idea would go down well in New Zealand, because there aren't that many other ways of leaving the country or moving around the country. But you can see the point that the search that took place in this case has a much more coercive element to it than the ordinary searches in an airport, and there's not the same element of accusation or culpability that surrounds it. So the European Court then focused mainly on Article 8, the right to respect for private life, home and correspondence, and that was why they mainly reached a different view. But they couldn't resist having a look at the other reasoning, which brings us back to Article 5, where we started. And on Article 5, the court said this: the applicants were entirely deprived of any freedom of movement. They were obliged to remain where they were and to submit to the search. And if they'd refused, they would have been liable to arrest, detention at a police station, and criminal charges. This element of coercion is indicative of a deprivation of liberty within the meaning of Article 5. So it's the element of coercion, it's the sort of background coercion involved in the encounter, which is what seems to incline the European Court towards the view that there was also a deprivation of liberty in this case, because if they tried to move on, if the two people had said, "You're not stopping me," then they would have been subjected to coercive powers. Now, I'm not going to say much more about this first situation. I think there is a grey area here in relation to police stops, whereas the European Court has tried to set the boundaries more clearly, the English courts have been obviously inclined not to do so. And once a stop has been made, of course, it must be on reasonable grounds. And reasonable grounds is not a particularly tight concept. It's incurably vague unless you have some way of giving examples or some other way of trying to make the legislation clearer. If we're looking for the values of the rule of law in terms of certainty, predictability, clarity of the law, then a law that depends on reasonable grounds is quite a long way from meeting that standard. And what I would like to see in this area would be other ways of providing guidance to the police about the situations which would reasonably cause them to have reasonable grounds for this type of suspicion. I think we can go further by means, for example, of codes of practice in specifying those elements. So I'll say no more about that, and I'll move on to my second area, which is police restrictions on movements as part of demonstrations. Now, here I want to talk about a device known in England as kettling. That is, when the police take a group of people and push them into a bounded area, a limited area from which they cannot escape. A side street, for example, which is a dead end, so that people cannot go any further. So this is what happened in the case called Austin and the Metropolitan Police Commissioner, a case that I'm going to talk about in a couple of minutes, but where there was a large demonstration in London against capitalism and globalization, thousands of people demonstrating. The police became worried about the size of the demonstration and decided to break it up by kettling about 3,000 people in a small street just near Oxford Circus in the centre of London. Now, the containment was carried on for 6 or 7 hours. They allowed about 400 people to leave, but the remainder, nearly 3,000 people, were kept for 6 or 7 hours in this area. Miss Austin asked to be released, but she wasn't released, and so she sued the police subsequently for false imprisonment. Now, in the House of Lords, the leading speech was given by Lord Hope, and he looked at Article 5, the right to liberty of the person. And he noted the fact that the European Court has said several times that there are only 6 exceptions. That is the ones listed in the Convention and no more. But he held that none of the 6 exceptions applied in this case, which they clearly didn't. So how is he going to deal with the case? Well, this was how he reasoned. Any steps that are taken must be resorted to in good faith and must be proportionate to the situation which has made the measures necessary. This is essential to preserve the fundamental principle that anything that's done which affects the person's right to liberty must not be arbitrary. If these requirements are met, it will be proper to conclude that measures of crowd control that are undertaken in the interests of the community will not infringe the Article 5 rights of individual members of the crowd whose freedom of movement is restricted by them. So this is the core of Lord Hope's judgment in that case. Now, he gave judgment against Miss Austin, and she has now taken her case to Strasbourg, where it's been argued, but the judgment hasn't yet come out. The government's argument was basically along the lines of Lord Hope's judgment, so we should, at some stage soon, get the court's reaction to his reasoning. My reaction is to suggest that there are at least 3 errors in the passage that's on the screen at the moment. I think the last sentence is particularly awkward. There is, of course, a mistake in the last sentence which Lord Hope couldn't help, and that is because he decided this case before the Strasbourg course had decided Gillen and Quinton, the case I was speaking of earlier. So when at the end he talks about the freedom of movement of people being restricted, I think Strasbourg is bound to hold that this was a deprivation of liberty and not a mere restriction of liberty as he was making out in that part of the speech. But Gillen and Quinton held that the 20 minutes that these people were detained was sufficient to violate their right to personal liberty. Here, I think the Strasbourg court would be bound to conclude that 6 or 7 hours confined in a relatively small area with no food, no drink, no toilet facilities must be a deprivation of liberty. So I think that's one error. But I think also when in that final sentence Lord Hope goes on to talk about crowd control undertaken in the interests of the community, that reasoning is just off limits. It's not human rights reasoning at all. If you can just produce the interests of the community anytime you like to weigh against human rights, they'd all disappear remarkably quickly. You can't do that. What you've got to do is to specify which rights of which person you are in fact trying to reduce. What Lord Hope should have said is something like the rights of other people who might be affected by the dangerous behaviour that was anticipated, or something like that, and then he'd need to specify what those rights were. So I think once you see the phrase interests of the community, that's an alarm bells. You won't see it in many Strasbourg judgments, but English judges are quite fond of that sort of reasoning. Now, so far as Lord Hope's judgment rather goes, there is one particularly intriguing and potentially very strong reason that he was able to produce for his holding that there was no breach of the right to personal liberty in this case. This part of his reasoning relied on Article 2 of the European Convention, which is the right to life, equivalent to Section 8 of the Bill of Rights Act. Now, the right to life is crucial, central, basic. There can't be any more basic human right than that one. So this is something of a trump card if it can be played in this case. Now, Lord Hope thought that it could, because he thought that the police justification, which originally was that they were kettling people to prevent a breach of the peace, the old common law power, actually meant, in this case, that they were trying to prevent danger of physical violence, including danger of death, arising if this demonstration had got out of hand, because there were unruly elements in it. So Article 2 here would be the Article 2 rights of people in the vicinity, passers-by, shop workers, police officers, and other demonstrators as well. Anyone whose life may have been put in danger, and there were enough people of that around. So the Article 2 rights were on one side, and then, of course, we've still got the Article 5 rights, the right to personal liberty, on the other side of the other demonstrators. So this looks like the court has to make some sort of adjustment, and it looks as if Article 2, being a very basic and powerful right that it is going to win this contest. But I think that's to move a bit too quickly, because before you can mount an argument based on the right to life, I think you need to lay the ground very, very carefully. And I'm quite sure that this is what the Strasbourg court will say. First of all, if you're going to talk about the real possibility of death or serious injury occurring, then you've got to have some real evidence. You can't just merely assert that. There has to be some evidential basis for thinking that. Otherwise, policing of demonstrations would be very easy, because the police would say every time, well, of course, there's danger to life, therefore we're going to do this. And that wouldn't be consistent with rights protections. So that would be the first point. You've got a real possibility of a risk to life. The second point would be that the kettling was the least intrusive measure, the principle of the least restrictive alternative, which I'll mention in a few contexts, comes in here. What the police do must be the least restrictive alternative. And then, if after satisfying those two criteria, we resolve that, yes, there was a risk to the right to life in this case, which was real, and which couldn't be dealt with in any lesser way, then, and this is the last point in the movement, the Strasbourg court will hold that the court must do its best to maintain both rights as fully as possible. In other words, the Article the right to personal liberty doesn't just disappear because the right to life, more powerful, is on the prowl. It's not like that at all. What the court must do is to preserve the maximum, to the maximum extent, the lesser right, and to ensure that any compromise, any lessening of that right, such as the right to liberty, is counterbalanced by other procedures. I go into this detail because English judges, when they get to this point, tend to say, oh, it's all a question of proportionality. And they don't reason through the hoops as the Strasbourg court does. So, that's a look at how I hope the Strasbourg court will deal with this case. And a more rights-conscious approach might result from that, a rights-conscious policing approach. It's quite interesting that the police, of course, like very much Lord Hope's judgment. And if you look at the police document, the Manual of Guidance on Keeping the Peace, it sets out 3 conditions for kettling. Good faith on the part of the police, measures proportionate to the situation, and enforced for no longer than reasonably necessary. All very nice and wide, and not with any of the qualifications that I put on them. The interesting thing is that after stating those 3 criteria, there is just a list of 21 judgments of the European Court of Human Rights, with no comment, one of them being Gillen and Quinton, which decides exactly the opposite of what is there. So quite a remarkable piece of police work there. Anyway, to carry on the story, this issue of the use of kettling has come up several times because the police have used it various times and there have been parliamentary inquiries about it. But it's come to the courts again in a couple of recent cases, of which I'll mention just one. This is a case called Moose and McClure, arising out of the G20 demonstrations in London a couple of years ago. Essentially what happened was that there were 2 large groups of demonstrators. One very unruly group who were roaming around the institutions of the City of London, including the Bank of England, and another peaceful group, known in fact as the Peace Camp, who were camped on one of London's squares a few hundred yards away in their tents. And as the afternoon wore on, the more angry crowd had to be managed in some way. So what the police decided to do was to break it up and siphon the people off towards the London Underground to try and get them to go away on trains. And they did this very successfully. But one group, rather menacing group, remained and began to walk in the direction of the peace camp. So the officer in charge decided that the best tactics was to kettle the police camp, the peace camp, the people who were in their tents, who'd been there all day, who were demonstrating, but actually hadn't been involved in any of the violence. So they were kettled, and they were also moved. The police got a cordon and moved the tents about 50 yards just by pushing them all into a heap. So there was quite strong action, but the action was taken against the peaceful people rather than in respect of the violent group, because the officer in charge anticipated that the violent group would come and stir things up, and he wasn't sure what would happen thereafter. So this is Moose and McClure, and you can see what the administrative court said when, on the action for judicial review of the police behaviour, was that the police may only take such preventive action as a last resort, catering for situations just about to descend into violence. This is referring to kettling. It's only when police reasonably believe that there's no other means whatsoever to prevent an imminent breach of the peace that they can, as a matter of necessity, curtail the lawful exercise of their rights by third parties. That's the peace camp. The test of necessity is met only in truly extreme and exceptional circumstances. So notice also in the middle of that passage the principle of the least restrictive alternative, that the police, there must be no other means whatsoever that the police can handle it other than kettling the people concerned. So this judgment of the administrative court was in fact reversed by the Court of Appeal. And I'll give you the reference in case it's relevant. But the Court of Appeal reversed it on what you might call a technical point. That is, they thought that the administrative court had actually focused on the slightly wrong question, but focused on whether a breach of the peace was imminent at the time, instead of focusing on whether the police commander reasonably believed that a breach of the peace was imminent at the time. So there was a slight defect in the way in which the administrative court had gone about it, but the Court of Appeal went out of their way to endorse the passage I just read out on the previous slide and say that was definitely the law. There's also this other case of Castle, which I won't go into today, but which is concerned with a demonstration which included children who were kettled and whether there are any special responsibilities towards children who are kettled. So, kettling then is an important tool in the police's armoury as far as controlling demonstrations goes, but it does have manifest disadvantages as well as curtailing liberty, which it clearly does. It has manifest disadvantages for the ordinary citizen who is there to demonstrate. It's used indiscriminately. It often sweeps up passers-by as well as demonstrators. Anyone who is around can be swept into a cordon in this way. It's disruptive to one's plans, of course, because one loses 6 or 7 hours often enough in a kettle. You can't go anywhere unless you manage to plead and get released. But it's not absolutely clear on what basis the police do release people. And, of course, it can cause inconvenience and discomfort because there's no food, drink, or toilets. So this is a major incursion of people's liberty, and as the administrative court said in Moose and McClure, it's something that should really be done only in truly extreme and exceptional circumstances. How the Strasbourg court is going to finesse this is not clear. As I say, we're waiting for the judgment. But I'm quite sure that even if the right to life argument is discussed and taken seriously, as I think it is, and Lord Hope seemed to think it was some kind of a trump card, because as soon as you bring the right to life in, then other rights have to move out of the way. So if the Strasbourg court takes that argument seriously, which I think it will do, then I don't think the next thing it says is that the court will have to balance the right to life and the right to personal liberty. I think what it will say is that it should maintain both rights to the maximum possible. And if the right to personal liberty is in any way diminished, then there should be compensating provisions in order to counterbalance that. In other words, procedural provisions brought in. So that remains a relatively vague area, and the right to liberty is under threat, I think, in that respect. Let me move on now to my third topic, and this is the right to bail. I want to ask the question, on what grounds can pre-trial detention be justified? Pre-trial detention. Now, the Section 24 of the Bill of Rights Act says that a person who's been charged with an offence has the right to be released on reasonable terms and conditions unless there is just cause for continued detention. And the European Convention is in broadly similar terms, but again, much more wordy. Now, the key issue starts when a person is arrested and taken to court for the first time, because the court has to decide then whether to remand on bail or in custody. And if custody is chosen, that is clearly a manifest incursion into a person's liberty, which may continue for several weeks. So this is a serious matter. Now, what sort of justifications can be brought forward for detaining someone before trial, for pre-trial detention? Well, I'll go quickly through this. You should all know approximately what they are. First of all, to ensure a person's presence at the trial, to make sure the defendant doesn't abscond. That's number one. Secondly, to ensure the defendant doesn't interfere with any witnesses or try to pervert the course of justice. That's number 2. Thirdly, to protect the defendant from attack by others. Doesn't happen very often, but occasionally a court may believe that a person might be lynched or something if released. And fourthly, and this is the one I want to focus on, the court may believe that there is a risk of this person committing offences in the period between the court appearance and the trial proper. Now, the European Court of Human Rights, as you'll see from the passages there, has given prominence to the presumption of innocence in talking about how courts should approach this. So, first of all, the judge, having heard the accused himself, must examine all the facts arguing for and against the interest of a genuine requirement of public interest, justifying, with due regard to the presumption of innocence, a departure from the rule of respect for the accused's liberty. A little bit convoluted, but it's a passage which keeps coming up everywhere and which really means that the court has to take account of the presumption of innocence and the right to liberty, as well as taking account of these public interest factors. And the court has also been very clear that any evidence produced must be specific to whatever the court is relying on as a reason for detaining the person. Thus, the danger of an accused absconding cannot be gauged solely on the basis of the sentence risked. In other words, you can't say because this person faces a severe sentence, therefore it's likely that he or she will abscond. And as far as the danger of reoffending is concerned, a reference to a person's antecedents, criminal record, cannot suffice to justify refusing release. So it's tried to require courts to be more specific in the sort of evidence they require before depriving someone of their liberty before trial. And also in the European Court, as in the New Zealand courts, there has been respect for the principle of the least restrictive alternative. So the New Zealand Court of Appeal has said that the societal interest must be enabled to be met by the granting of bail upon terms as to residence, reporting to police, curfew, non-association, and so forth. So the principle of the least restrictive alternative applies here as well. Now, on what basis then, on what type of evidence might a court act? Well, if we're talking about the risk of absconding or interfering with witnesses, usually the court will be given some specific evidence which points in that direction, perhaps previous behaviour of the person, something like that. But what happens when we come to this business about the prevention of offending, detaining someone between the first appearance and the trial in order to prevent them from offending? Well, you could have a threat against a particular person. That would be a reason for detention in that sort of case if there was no lesser alternative. You could have evidence that the person has, when granted bail before, committed offences. That might be a reason. But if you don't have any specific reasons of those kinds, what is the likelihood that someone will reoffend during that period? Well, attempts to gauge that statistically have not come up with a very good success rate, around 20 to 25% in England, and I think probably the same in New Zealand. But then the question really is not just about statistics. The question really is, what is the responsibility of the state in relation to this person's conduct between the time of first appearance in court and the time of the trial? Why is the state responsible for his or her behaviour during that period? Why is this person any different from someone on the street who the police don't like the look of and know to have a bit of form or perhaps some previous convictions? Why can't the police sweep people off the street? Well, of course, we don't allow them to do that, just as a matter of course. So why should we have a different rule simply because someone's been charged with an offence? Why should we say, oh, well, it's, the state needs protection in this period? Why does it need protection from someone who's been charged and who enjoys the presumption of innocence? Well, you might think one reason is that at least this person has been charged and therefore a prosecutor has applied her or his mind to this matter and there's been a quasi-judicial decision to charge this person. Well, you could go down that road, but there are certain difficulties with that. One being that at the first court appearance, the prosecutor often doesn't have a full file, doesn't have evidence on all the elements of the offence, hasn't received a report or two that's required. So actually, at the first court hearing, there really isn't very much evidence at all. And if we really are relying on the fact that the prosecutor's taken a decision at that stage, then we're really placing a lot of emphasis on trusting the prosecutor rather than on any objective evidence which may not be there at that stage. So I'm not sure whether the argument that a decision to prosecute has been made is strong enough to justify any responsibility of the state for the conduct of this person between the first court appearance and the trial. A further strand of difficulty is the presence among this group of defendants of many people who intend to plead guilty. Certainly in England, about half the people who are prosecuted indicate from quite an early stage that they intend to plead guilty. If that's so, you might think we don't need to be as concerned for the presumption of innocence in these cases because they're going to plead guilty anyway. But again, I think we've got to be very careful with that line of reasoning because it doesn't on its own justify pre-trial detention. It might justify pre-trial detention if we can say that this person will be sentenced to a significant sentence of imprisonment. That might be a satisfactory reason. And courts, but of course that is not, as I understand it, a requirement of New Zealand law at the moment. It's certainly not a requirement of English law that before a court remands a person in custody who intends to plead guilty, the court needs to be sure that a prison sentence will be passed longer than 3 to 6 months, let us say, longer than the time they would spend on remand, in other words. I think if such a provision were there, and I think it should be, then it wouldn't be difficult for courts because they are accustomed to giving advance indication of sentence or are becoming accustomed, so they should be able to handle that. But I think that looking at all these matters, there are various things you can tie up like that into little bundles and say, well, that deals with those cases and that deals with those cases. But at the end of the day, I'm still worried that I haven't found a convincing explanation of why the state is responsible for the behaviour of a defendant who has been charged with an offence, who intends to plead not guilty. Why is the state responsible for that person's conduct prior to the trial, in the sense that it then feels that it has to put them inside if there is thought to be a reasonable grounds for believing that they would commit offences in the period before trial. So I leave that with you as an open question. I'm worried that I haven't yet seen a convincing answer to that question. Now, the fourth of my topics is indeterminate custodial sentences. I want to look at the justifications for indeterminate sentences on dangerous people. You have a preventive detention sentence in New Zealand. In England, we have a variety of models, one of them called IPP, Imprisonment for Public Protection, which is indefinite. So the person has to make a case to be released. Otherwise, it can extend for life. So these are very serious incursions into liberty, and the question is, how can we justify them? They're only justifiable, certainly, if there is sufficient evidence on which to predict successfully that a person, if released at the end of his or her sentence, would commit offences. We've got to have some reason for believing that the person would commit an offence if released. There's a lot of empirical data on this, large studies done in the United States, but the fact is that very few studies have come anywhere near the 50% mark. And most of the best studies suggest that they get, if you predict that a person will commit a serious offence on release, 2 out of 3 predictions are wrong. Now that has led the present English government to the statement which you see there. The Green Paper, which is a pre-legislative paper issued by the Ministry of Justice, said this: the limitations of our ability to predict future serious offending call into question the whole basis on which many offenders are sentenced to these kinds of indefinite sentence like preventive detention. Now this is quite remarkable. This is a Conservative-led coalition which has come up with the sort of statement that you might expect to come out of some bearded left-wing criminologist. Sorry, Jeff. This is amazing. This sort of statement has been in the criminology books for years. Now we have a government actually stating it and believing it and acting on it, actually, because they're removing this IPP sentence from the statute book and replacing it with something which is much, much narrower. So there is an important issue here. This suggests that people's liberty is being taken away without sufficient justification. Can we get over that? Is there another way? Because a lot of people instinctively think that these people who are given these sentences are dangerous. If you speak to people in the prisons, they'll say, yes, he's dangerous, you let him out, he'll go and do something nasty. So there are a lot of people around who believe that there are dangerous people. The question is, how do we identify this group, and do we have any justification for giving them indefinite detention? One argument would be the so-called precautionary principle, which is used in environmental law to deal with cases where there isn't sufficient data, but there is the possibility of catastrophic consequences occurring if no action is taken. So there may not be sufficient data on which to take the decision, but there is a possible catastrophe awaiting, and the precautionary principle has been used in that way. Whether it can be adapted to the present situation, I'm rather more doubtful about. In the first place, we don't have a data gap. We have plenty of data. The thing is that the data don't yield the results that many people want them to yield. So we do have data. The other thing is that I think the precautionary principle, although it's used in various ways, would really not be the sort of principle that you'd use to deprive a person, or indeed many people, of their liberty. That's serious business. Precautionary principle may require certain safeguards to be put in place to avoid catastrophes on an environmental footing. But actually depriving people of their liberty is a different matter. This is the most severe permissible sentence we're talking about, and the most severe deprivation of rights. So I'm not sure the precautionary principle will be equal to that. The other way of tackling this would be to tackle it on a normative level by suggesting that a person who stands before the court convicted of a serious violent or sexual offence, and has one previous offence of that kind also, has forfeited the presumption of innocence, or has forfeited what is sometimes called the presumption of freedom from harmful intentions. We no longer presume that person is free from harmful intentions. They've shown twice that they're quite capable of entertaining and acting on harmful intentions. So we can then justify applying to them extra powers. Now, even if that kind of forfeiture of rights argument is sustainable, and I think there's a lot of argument about whether it is, but even if that sort of argument is sustainable, there is still the question that we're talking about a less than 50% success rate. So we are bound to detain for those purposes about twice as many as people who we actually would need to detain, although we can't tell which ones they are. So there is a problem there. But as you look across the world, you still find that almost every jurisdiction has a sentence of this kind that is aimed at preventive detention for people who seem to present a danger of serious offending. If we're going to go down that road, then surely what we should think of is something different. And this is what the European Court of Human Rights has been trying to argue in favour, the most important case being M against Germany in 2010. So if the detention really is preventive and not punitive, it's for prevention, rather like quarantine, it's purely for prevention, then it should be served in separate institutions, not prisons. And there should be additional and substantial measures of treatment and support available to the detainees. Now, that's similar, you might think, to what we do to mentally disordered people who are thought to be dangerous. These people, on an analogy with quarantine, might be dealt with in the same way. So I'm not accepting at the moment that there is a knockdown case for preventive detention. But I'm suggesting to you that if we do go down that road, and most countries do, then what we need is to recognise that we ought to package it differently. We ought to call it something different. We ought to have procedures and facilities that recognise that this is really a different thing. We are detaining these people in order to protect society and in order to have a preventive result. Okay, so what I've done in looking at these 4 problem cases is to suggest that the right to personal liberty is being eaten away from various angles or threatened from various angles, usually for preventive reasons, usually on the argument that this is necessary to prevent harm. Extra powers are necessary in order to prevent harm, in order to allow the police to carry out the duty which we expect of them, which is to protect us and prevent harm. The difficulty with the preventive argument is that it's a very easy one to make, and there's no real end to it. And for this, I go back to something that John Stuart Mill stated in his famous essay on liberty in 1859. He said this, that the preventive argument is far more liable to be abused to the prejudice of liberty than the punitory function. For there is hardly any part of the legitimate freedom of action of a human being that would not admit of being represented, and fairly too, as increasing the facilities for some form or other of delinquency. So there he is. He's saying that the preventive argument is a very easy one to run, and insofar as it clashes with the right to personal liberty, my message this evening is that it's something that we should watch very closely. Thank you.
My pleasure to ask Debbie Erickson, who is the President of the Otago District Law Society, to propose a formal vote of thanks to Andrew. Debbie.
Professor Hennigan, Professor Ashworth, ladies and gentlemen, here in Otago, the link between the law faculty and the profession has always been a vital one. We have a law faculty representative on our New Zealand Law Society Branch Council, the President representative being our Vice President. Many members of the profession are involved in varying levels of teaching students here at the faculty. I would like to believe that this link provides us with a unique opportunity for all of us to benefit, and the guest memorial address is a prime example of this synergy. This evening's address is an extremely topical one. The basic principles such as the right to liberty and the issues surrounding that are something which, when considering criminal law matters, are not confined to the academic sphere, but are also central to us in practice. This is not only true when dealing with each and every client, but also when considering the criminal justice system as a whole. The current changes, in particular, the granting and administration of legal aid, raise these issues on a wider level. As practitioners, we are certainly concerned with these changes and the way that they will result in individuals not receiving an appropriate representation to ensure that the least restrictive alternative is, in fact, being fully considered when that question of an individual's liberty is being considered by the court. So, is the democratic compromise being pushed too far? Professor Ashworth, on behalf of the profession, the faculty, and all of those present this evening, I would like to thank you for a most thought-provoking address.